Good morning, everyone, and welcome to WorkCover Queensland's Common Law webinar, where we will be discussing mental injury claims and what employers need to know about them. My name is Tim Lose. I'm a lawyer at WorkCover Queensland, and I will be your host today. Before we get started, I would like to acknowledge and pay respect to Queensland's elders past, present, and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters, and community. We will be recording this session and we will send a link to the recording by email early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Please feel free to submit any questions during the webinar using the panel on the right-hand side of your screen. We've actually received quite a few questions already, which our guest will be speaking to, or some of them at the end of the talk, and we'll do our best to get through as many as we can in the hour that we've got. I would also like to just mention a few online resources relevant to this topic that might be of interest to listeners. First, the Workplace Health and Safety Queensland has developed and released a code of practice called Managing the Risk of Psychosocial Hazards at Work 2022, developed under the Work Health and Safety Act 2011. So that takes effect on 1 April 2023. It's a practical guide on how to prevent harm from psychosocial hazards at work. That's online now. The second one is the Committee for Economic Development of Australia, which is an independent membership-based think tank, actually released a report yesterday called Mental Health and the Workplace, How Can Employers Improve Productivity Through Wellbeing? So in that report, they've noted a projection of work-related mental health claims looking to double by the year 2030. The report talks about trends in mental injury claims and initiatives to support workers. That's online for free access as well. They're not associated with WorkCover Queensland, but it's an interesting report. We're going to put the links to those underneath the YouTube video, but both of them are online now if you just want to do a search for those things. All right, now I would like to introduce today's presenter, Phillip Carlson from HopgoodGanim. Phillip is a senior associate in the insurance practice. He advises in all areas of insurance litigation. He has over 15 years of experience advising clients on complex work cover, public liability, motor vehicle, professional indemnity, and general insurance matters. Phillip has also advised various organisations in Fair Work Commission matters, including unfair dismissals, general protections, and stop bullying applications. Welcome, Phil, and thank you for taking the time to prepare and present to us today. Before I hand over to Phil, I'd just like to remind our listeners that any information provided today by WorkCover or HopgoodGanim, including in response to questions, is general information only and should not be taken as legal advice. All right, that's all from me. I will now pass over to Phillip to discuss psychological injury claims. Thanks, Phillip.
Thank you, Tim. Today I'm going to be discussing psychological injuries in general context in relation to WorkCover claims. And the agenda on screen is more so a guide. When confronted with a psychological injury claim, dealing with them are daunting, sometimes very confronting, and often quite personal. And that's just from an employer's perspective. For the claimant, however, the injury is all of those things and often becomes all-encompassing, which can create a bit of a circular dilemma for those around them, with the injured worker tending to spiral down deeper into their own injury. Dealing with these claims must be done thoroughly, and ensuring investigations are completed early and fully with consideration of all possible issues can lead to far better results for not only the organization, but also the injured worker. Not part of this presentation, and likely a topic for another, is ensuring workplaces have regard to the possibility of workers obtaining orders from the Fair Work Commission to stop bullying or to stop sexual harassment. It is relevant to speak about these briefly, as bullying and sexual harassment are usually intrinsically linked to workplace psychiatric injury claims. Fair work orders don't have to be limited to any one person or organization in the workplace, but there must be a continuing connection with the workplace for orders to be made. Further, the purpose of the orders, similar to the new Queensland Workplace Health and Safety Code of Practice, the Managing the Risk of Psychosocial Hazards at Work, is to ensure the safety of employees from future harm and enabling normal working relationships. At the end of the presentation, if we have enough time, I'll discuss a few interesting cases which we have recently been decided in Victoria, which will likely have an impact on how future cases are decided. I'll also be answering a few questions which have been posted beforehand, as Tim mentioned earlier. Next slide, please, if it's all right. The Workers' Compensation and Rehabilitation Act is the starting point for deciding any workers' compensation claim, whether it be for physical or psychological injuries, And to be clear, this can include aggravations of pre-existing injuries. The part of the sentence at subsection 1, where it notes about arising out of or in the course of employment, if employment is a significant contributing factor, is quite important. And a few cases are decided on this aspect alone. Think, for example, of an injury where a worker has significant pre-existing osteoarthritis in their foot and suffers a broken bone while simply walking up a set of stairs. The stairs are safe and up to standard, and the worker wasn't running or acting outside the normal scope. Should this be an accepted work cover claim? Well, you might not know that whether or not the worker has significant pre-existing osteoarthritis. Neither may the worker. But unfortunately, the worker, or the injury is debilitating. The simple question to ask, though, before agreeing or accepting the injury at face value to work cover is, was the injury caused because of work, or did the worker simply suffer an injury at work? Asking this question at the very outset can save quite a lot of time and energy, as it may lead an organization to consider challenging an acceptance with the workers' compensation regulator. What is a psychiatric injury? It's actually easier to define a primary psychiatric injury by what it isn't. It is not a psychiatric injury arising out of a physical injury. For example, a worker hurts their back and is incapacitated. They later develop an adjustment disorder or other psychiatric illness as a result of the impact of the physical injury. It is a psychiatric injury which is a direct result of a non-physical injury or largely non-physical event at work, such as bullying and harassment. We all know what this one is, and most employers have a bullying and harassment policy. It is generally perpetrated by a coworker, but could also be by a supervisor or subordinate. I would also include here workplace assault, where the physical assault is minor and the real issue is the feeling of being unsafe at work. Exposure to traumatic event. This is particularly relevant for emergency services personnel, military, service station attendants involved in armed robberies, construction workers and mine workers who witness serious injury or death of a coworker, train drivers, truck drivers who witness suicides, counselors, social workers, even solicitors who suffer vicarious trauma by hearing about or reading about trauma suffered by their clients. Overwork is another. We don't see this one quite as often, but it comes up when a worker is asked to take on extra work due to a coworker being away or a looming important deadline. The worker might start working longer hours or take work home, and it snowballs from there. There might also be a feeling that if the worker does not stay on top of the work, he or she will lose their job, or that the employer business may fail, resulting in everyone losing their job. Investigations, such as a worker making a complaint to an employer. This is often a complaint about bullying and harassment, but could also be a complaint about health and safety issues in the workplace. Whistleblowing regarding other issues in the workplace. There was, in fact, recently a matter before the QIRC where one of the allegations was that the worker discovered child pornography files on a computer, which was owned by an educational institution, raised that issue with management, and they were not satisfied that management had properly investigated and responded to it. This is then tied up with the worker's perception of how the employer has investigated and responded to the complaint, and I'll actually speak about this claim later. Performance management. This one is pretty common. Worker is involved in a performance management process, whether it be formal or informal, and makes an allegation of psychiatric injury arising out of how that performance management was carried out. Commonly involves allegations that the worker felt ambushed, the meeting was called at short notice, the worker wasn't afforded a support person, the worker was not given an opportunity to respond and or improve. Decision-making process. These can be formal or informal processes. Formal processes might include decisions about promotion or transfer, decisions about flexible working arrangements. Those are more and more common these days. Informal processes might include decisions about resource allocations or division of tasks between coworkers. Any decision where there can be a perception that one coworker is favored over another, for example. And as we go through, we need to think about whether the allegation is directed at a single person within the employer organization for whom the employer is vicariously liable, or whether the allegation is directed at the employer's conduct. This is particularly relevant when we look at the best way of communicating with the injured worker. Going down the list, we see this. Bullying and harassment is usually an individual issue, with the rest of them being about employment. So reasonable management action is one we get questions about a lot, and we see lots of claims about this. So out of all these potential psychiatric injury claims previously mentioned, it is important to determine whether the factor complained of is management action or not. And if so, was the management action reasonable? I find it easiest to think of management action as being administrative action, or the way that the employer is managed in their duties, versus operational action, or the way the worker performs their duties. Where there is a multi-factor claim, where a worker complains about several different factors having contributed to their psychiatric injury, it's necessary to consider whether or not each factor is management action. A judicial example of this is the case of Alwood versus the Workers' Compensation Regulator. This is the claim that I was talking about previously. There are 4 general factors that were identified by the court. Some of them weren't management action and some were. In this one, however, even the management action wasn't considered reasonable. So the claimant in this situation was successful. And it's, these cases are really important to read, and sometimes they can identify things that organizations can do better. However, so as not to get bogged down in reasonable management action issues, we'll keep moving. What you should know, I have done whole presentations based entirely on this topic alone, as it can be quite daunting for most organizations to get their head around. The reason for this slide is that the decision highlights the injury that has to be considered as a whole and not just one aspect of the, at times, myriad of issues. The injury is determined based on the balance of probabilities, in essence, that more than 50% of the injury is not excluded under the section 32.5 for reasonable management action. And the obviously various other factors which have to be addressed as well. In many instances, the employer is required to continue to communicate with the worker during the statutory claim. This might be because the worker remains employed by the employer, because the investigations regarding any incident or complaint are ongoing, and natural justice requires that the worker be kept informed of the outcome, or because the employer has an obligation to provide rehabilitation and return to work options. In some instances, however, the worker will decline to communicate with the employer at all, instead requesting that communication be through the workers' compensation insurer or through their lawyers. All these requests can be frustrating. It is imperative that the request be adhered to limit further aggravation or potential common law claims. The WHO, where the primary allegation is directed against the employer rather than an individual, continued communication may in itself cause difficulties. This is especially so if the employer representative was involved in the subject of the allegation. For instance, was the HR manager involved in the performance management process? In these circumstances, it might be prudent to liaise with the insurer about whether communication should be directed through the insurer instead. The method of communication is equally as important. Consideration should also be given to the best method of doing so. Some workers will insist on email communication only. In other instances, workers might be happy to be contacted by phone, but it also might be prudent to confirm the outcome of that conversation by email. This is especially so where the conversation has resulted in an agreement that either party will do something, and it ensures that there has been no miscommunication about that agreement. Record keeping. It is essential that accurate records are kept of each communication. The reason for this is threefold. Firstly, in many jurisdictions, documents regarding rehabilitation and return to work are disclosable in a common law action for damages. This will include file notes of telephone conversations and emails. Secondly, it is not uncommon for workers to make allegations about employers' conduct during rehabilitation and return to work, and it is prudent to have a record of this. Finally, these records can form the basis of a failure to mitigate argument should the worker bring a common law claim for damages. For instance, the employer may allege that the worker failed to properly participate in return to work endeavors, and as such has failed to mitigate his or her loss. The employer may then produce documentary evidence showing that attempts were made to return the worker to a modified or alternative role within the restrictions imposed by medical specialists, but that the worker resisted those attempts. Record keeping should be contemporaneous, kept in chronological order, and identify the person conducting the investigation. For instance, I've seen lovely type notes kept by an employer that were completely useless because years down the track, we could not identify who was involved in each conversation and who made the notes. To that end, notes should not contain abbreviations unless they are commonly understood abbreviations. I would also encourage type notes rather than handwritten notes, as some handwriting can be very difficult to understand. Communication with the worker can absolutely be a key factor in whether the claim succeeds or fails. This is often because injured workers often feel employers want nothing to do with them once they lodge a claim. And while I've seen this on numerous occasions, this should not be what occurs. Communication goes hand in glove with ensuring a fully transparent investigation is undertaken. I've seen many claims come through regarding an employer's failure to properly provide all evidence collected, or for example, to only interview employees supportive of the employer's or manager's positions. It is worth attempting to have an uninterested third party undertake the investigative process so that there can be no allegation of or actual bias. This outside party can simply be a manager from another section who has not had interactions with or been involved in the subject injury. Now, I've got 9 different types of documents you might gather. Usually I would get everyone in the presentation to stop listening and take 2 minutes to actually write down the evidence that they would gather in a psychiatric injury claim, or any claim for that matter. But in this presentation, I'll just go ahead and tell you mine, as we're somewhat reasonable on time. We want to be able to answer as many questions as at the end as we can. The first is policies and procedures. This includes policies about performance management, promotion. A recent claim before the Court of Appeal was focused on the employer's policies and procedures regarding responding to a worker who had been exposed to a traumatic incident. The focus was on the procedure in place rather than the traumatic incident itself. In that instance, preservation of the policy or procedure as it stood at the time was crucial. This brings me to another point. The reason why we want to gather all of the relevant policies and procedures as close to possible to the inception of the claim is that policies and procedures change over time and often change in response to an incident. And there can be confusion down the track as to which version was applicable at the time of the incident. So preserving the relevant version at the time of the incident, we can avoid that confusion. The next is evidence that all relevant personnel were trained in those policies and procedures. You can have the best policies in the world, but if you can't show that the relevant personnel were trained in those policies, you are missing a crucial link. What we often see is either a sheet where all the personnel have signed that they attended a particular training session about a policy, or an individual record to show that a particular worker was trained in a policy. The problem with that in isolation is that we have no way of showing what the contents of the training involved. Think about attaching any of the training materials, PowerPoint slides, video file, etc., to the back of the sign-off sheet. This sign-off sheet should also identify the version of the policy relevant at the time of the training and the person who was leading the training. If there was any assessment of competency after the training, this should also be attached to the sign-off sheet. The next is documents produced during the course of the event. These include written complaints, incident reports, meeting minutes, formal letters issued, diary notes. Make sure, again, it's clear who made the diary note, when it was made, and what it says. If it's handwritten, you may want to do this by way of a statement. The next is documents produced in the aftermath of the event. Where the event was exposure to a traumatic event, the documents may mostly relate to the aftermath, such as incident reports, investigation reports, workplace health and safety documents, and other similar type documents. Other things may be time cards, swipe cards data, vehicle logs, computer login times. Sometimes it's necessary to establish when a particular person was on site or was working. It has relevance to claims of overwork. It has relevance to claims of bullying and harassment. They need to establish, whether 2 people were actually on site at the same time. The next is CCTV footage. This is often an afterthought, and by the time the footage has been wiped, it's usually too late. CCTV footage of an event or footage that establishes the comings and goings of staff in a bullying and harassment claim can be very important. The next is Facebook social media screenshots. Most lawyers tell their clients to lock their social media pages. It is possible to get a court to order compelling disclosure of Facebook material, but there is not a lot of precedent about this, and a better option is to preserve any social media material before the worker locks it down. Some employers and supervisors are friends on Facebook and Instagram, etc., and it's good to see what they were doing at the time. Again, it provides a timeline of events that occur as well. If you're doing this by screenshot, you need to make sure the screenshot shows when the post was created. If not possible, obviously when the screenshot was taken. We do this, we see this more and more in physical injury claims. I had one recently where the worker had posted about a non-work-related injury to the same body part about 5 months before the relevant statutory workers' compensation claim. And thankfully, the employer jumped in this early and preserved that evidence, which we're able to then further corroborate with evidence from her GP.
Sorry, Phil, to just jump in there. I think the two is just a bit disconcerting. So I might just to the next one. Just, even if you don't speak to it, we'll just keep
that's
on
fine.
that.
Yeah, that's fine.
Thanks.
The next is phone records. Relevant where they may be dispute regarding the timing of phone calls. For instance, where a worker says she wasn't notified of a performance management meeting until the morning of the meeting. The employer is able to produce a statement by her manager, which shows they notify her by phone at 3 o'clock, 2 days before the meeting, and the phone logs show a call was placed to the worker at that time. The phone log might not corroborate the contents of the conversation, but it lends weight to the statement provided by the manager and creates a real need for the worker to answer that allegation. They're also relevant to where there is an allegation of bullying and harassment by phone calls. It can be used to demonstrate the frequency of those phone calls. Lastly, the ninth is similar to phone logs, text messages. You'd actually be surprised how many times the work phone gets wiped and provided to another employee before anyone realizes that the text messages should have been preserved. What we've got on the slide right now is an example statement. It's a couple slides long, but what it does is it shows in black a similar statement that I've received, and that, yes, there is some material on that statement that's relevant. However, the blue shows other things that should be added to the statement, which gives it quite a bit more weight. The red, however, shows things that you probably shouldn't use. So obviously at number one, you want to say who you are or whoever's providing the statement, their period of employment and their role. They note that in number two that they're giving a statement for a very specific purpose. Number three, they're identifying what occurred and what is the process of what happened on a very specific day. Again, the black isn't horrible, right? But it could be better, right? Mentioning before about swipe cards, logs, and vehicle logs, etc. Having evidence of those things only lends credence to the statement further, notifying that they've got a statement or they've got a swipe card number, exactly what time those things occurred. Moving forward, when you look at number 9, this is a pretty common statement that someone saw them push someone else. Okay, that's fine. However, how did they push them? Was there, what occurred after the pushing? What happened to the person who was pushed? What happened to the person who did the pushing? And how it was actually witnessed and confirming that that was occurred. Again, number 11 shows that what happened afterwards to the pusher, and then obviously to Betty who was pushed. Steps that are taken afterwards to show that all relevant actions were taken or as best could be done at the time. These are usually very short processes in time, and getting this information down is entirely problematic at times because people forget really quickly about what happened. So statements should be taken contemporaneously and as quickly after an event as possible. Again, sometimes words such as afterwards or very, they don't really add much. When you're looking at it, very is a very general word, which doesn't actually identify what very means. So you're describing later on that you could see that they were upset because of certain things and issues, trembling, tears in the eyes, etc. The last thing is you get statements like this, and they end without being signed or dated or witnessed. It's hard to then prove later on that that person said those things, or that it was actually written by that person or authorized by that person. So definitely there are bonus points for getting statements signed, witnessed, and dated. And again, printing, neatly the name of the witness is also really important. What's also not on there, and actually I'll raise it quickly, is that getting a phone number or some contact details of that witness can be very important for people like me later on when I have to investigate this matter. The chronology is something that, again, not a lot of people use, but it can identify gaps in the evidence. This is one of those issues that it helps you identify what material can be organized or can be found. And there's a lot of times that this information, again, will lead to other information being obtained. If you can just click through, there's a couple of added bits on there. So looking at this, there's, what you rely on to confirm those bits in your chronology. So you're relying on the bullying and harassment policy as at a very specific date. You're relying on the bullying and harassment training slides, for instance. You're then saying, well, these events occurred in this order, and then as the evidence relating to that, you then identify how you are relying on that to confirm what occurred. So for instance, Mary's statement, Bill's statements, and a roster of who was on and when. Further, swipe card logs. And also at the end, obviously, if there is CCTV footage, that it's been saved. So not just viewed, but saved. Obtaining that information later on is almost impossible because it's either deleted or whoever saved it in some location, then no one can find it. So again, everything as much as possible should be contemporaneous. All documents should be saved, and that best case scenario is that there is a file specifically identified about this specific event, and it can be readily provided to whoever needs to investigate this. And further, most documents that are provided or are produced will be disclosable. And it becomes a question of fact later on, or in essence, there's an inference that can be drawn by the court. If you don't produce certain documents, the court can say, well, you had that document at some point, you didn't produce it because it actually gives a bad result for you. And that's not what you want to do. You don't want to have a negative inference given when the document existed and it was perfectly fine and reasonable. So contemporaneous evidence is best by all means. Again, any person involved, their phone numbers, contact details, people leave organizations, and we just need to make sure that any relevant person is identified and is able to be contacted later if we don't have statements that are contemporaneous. So I draft them for myself, but just to cross-reference what I've got. So one of the issues here, and this is a couple of recent cases that have been decided in Victoria in October. So they're very, very close in time. I'd like you to have a think about these two claims. And what I'm going to do is I'm going to ask you a question now, and it could be a trick question, but think about these two series of events and which one do you think was accepted? The first one is called Garrett and Victorian Work Cover Authority. It involved a situation where there were two armed guards. They were driving a vehicle back from a location, so they were at work performing their duties. The injured worker had no prior psychiatric history. While driving, the other guard, who's sitting in the passenger seat, pulls out his weapon and points a loaded gun at the head of the injured worker. There was no reason why that occurred, simply that he liked guns. And, he's got Facebook posts previously showing that, oh my gosh, I can't believe they gave me a gun. The event occurs, again, after performing their duties, but still on shift. As I mentioned before, the guard who pulled his weapon was charged and convicted by police. The worker suffers psychiatric injury, obviously having a loaded weapon pointed at his face. The next one is Bell versus Nexus Primary Health. This one, the injured worker is a family violence outreach worker. The worker had significant prior psychiatric issues, of which the employer knew about. And in fact, she had been hospitalized because of those prior psychiatric issues during employment and prior to the workplace event. On her way to work, she stopped at a chemist. She was attacked from behind by an unknown assailant. This person, to bring it to, into the sphere of work, this person said, "You people ruin lives and ruin families." She had been previously threatened, however, not with physical violence, by a former husband of the employer's client. That worker also suffered psychiatric post-traumatic stress disorder. So I've given you a few minutes to think about that, or a couple minutes to think about that. The issue here is, are they related to work? I'm going to tell you, and I get a lot of shock with this, is that the one that failed was the armed security guard. That claim failed. His claim was dismissed from court simply because the employer could not have possibly ever considered that a coworker would point a loaded weapon at another coworker. It is obviously now within the knowledge of that employer, but you can't rely on hindsight in determining these things. So the claim was obviously determined based on what was known then, and in that instance, the claimant failed. In Bell, the claimant was successful. The reason why she was successful is because the employer knew about that previous threat from the former husband, and the employer should have taken steps to remove that client from her portfolio. And yes, it might have prevented the injury from occurring to her. However, it begs the question, it's likely that this person, who's significantly aggravated would have attacked someone else. So while she succeeds, if she had been transferred, someone else might have still been attacked. So it's kind of a very interesting question, but you can see why it was successful, because there was obviously a connection with work that was made, and the prior threat brought it back to her work duties quite significantly. Now, obviously, it's a different system in Victoria than it is in Queensland, but they are Supreme Court matters, both of those, and they obviously do have effect because they both rely on a High Court authority of Prince Alfred College, which talks about vicarious liability of employers for criminal acts, and both of those are obviously criminal acts perpetrated by, one by an employee, another by an unrelated entity. So it can be quite difficult at times to identify what's right, what's wrong, which should be accepted, which shouldn't be accepted. The last time I spoke about these two matters, on Melbourne Cup Day, everyone in the audience identified that the security guard should have been accepted. And in fact, had their mouths open when I told them that was not in fact the case. So that's it as far as my presentation. There's a couple of things that are happening. I know that one, there is a matter that's currently was determined by the High Court recently. This is a matter of Shockman. That case also deals with a physical and psychiatric injury arising out of what is in essence a criminal assault by another employee. That one is being determined by the High Court currently. I know that they've made their submissions recently in the appeal. So I know that WorkCover is waiting with bated breath on the outcome of this. But this one will have an outcome and effect on a lot of employers who have camps and house workers at those camps, because it's in essence a contractual requirement for those workers to stay at camps, and that is in essence what this claim is about. So we'll provide an update at some point, I'm sure, about that claim and the outcome from the High Court when it's finally determined. I guess I've got a number of questions that have been raised. Tim, do you want me to talk about those now, or do you want me to go?
Yeah, that's fine. If you've got some of the questions in advance,
I do. Yeah.
Speak to, that's great. And we've got a few more up on the screen that I can ask as well.
Okay.
But if you start there, that's good. Thank you.
So hopefully some of these address some of the issues that I might not have raised, but I hope that I raised or at least spoke to some of the other questions that have been asked. The first question that I've got is, do medical psychological injuries, for example, inherited bipolar disorder, affect a worker's rights to claim when another injury occurs? The quick answer is no. A pre-existing condition doesn't affect the right of a worker to claim common law damages. There are, however, many facets which go into answering the question fully, and really those usually depend on the level of disability which arises because of the pre-existing injury. While not affecting specifically the right to claim, a significant pre-existing injury will usually affect the damages paid in a common law claim, for example. But this is also tricky, as while the worker may have had a pre-existing injury, they were, in all respects at the time of the injury, performing their work without problems because of it. And that obviously leads to other outcomes in a common law claim. The answer is one which depends on each person's circumstances and is almost, in essence, impossible to provide a one-size-fits-all response. As with most of these questions, they are, somewhat complex issues. So, there's a fair bit of interplay between what occurred in each very specific event as to what happens. But in essence, a pre-existing injury does not prevent a worker from claiming common law damages for another injury. The next question is, how is employer negligence determined in common law for a psychological injury claim, or is it determined at claim acceptance? Again, a quite complex question rather. In short, liability in a common law claim for any injury is not determined at a statutory claim acceptance. WorkCover accepts a liability to pay statutory benefits, but that's not the same thing as liability in common law. To understand, you have to first understand the difference between, the statutory claim and a common law claim. So every Queensland injured, quote, worker, as long as they meet certain legislative criteria, is able to claim statutory benefits. This is not the case, however, for access to common law damages. There are specific legislative sections in the Act which deal with negligence and causation, which must be proven by the claimant to succeed, and that can be quite arduous at times. But don't think that just because the claim was initially accepted, that this always means that the claimant will have a successful common law claim. The ultimate key is having enough information, documents, evidence for solicitors like me to be able to determine and defend claims. I have, had recently claims which seem to be successful common law claims at the outset. However, what happens is that there's a fair bit of instances where that's just not the case, where the claimant cannot prove their injury occurred A, because of work, simply it happened at work, or B, that the employer could have done anything to prevent the injury. So injuries occur, and sometimes they're simply accidents. Sometimes injuries happen at work and not because of work. And that is, or can be, a very key question, and can defeat claims in their entirety.
The stat claims, I think they're informally referred to as no fault claims. So you can have a statutory claim accepted without the employer having been negligent in causing your injury, and whereas the common law, there has to be that negligence element that you just touched on.
Mm-hmm. Yeah. And sometimes work cover, the claims officers say that the employer has a liability, to accept the claim. However, that's the term liability is more complex than simply a word. So again, don't think that liability means the same thing in statutory and common law positions. The next question is there a process of requesting provisional liability if there's a question about the validity of a claim? So provisional liability is not a system used in Queensland. It's usually a system used in New South Wales, for example. There are certain classes of workers who have access to presumptive legislation, but it's not the same thing. In Queensland, work cover must first make a decision on the claim about, after their initial investigation process has been completed. Either the employer or the worker can then seek to appeal that decision to the workers' compensation regulator, who will in turn then review the evidence provided by work cover and the claimant and the employer. And they have the power then to either confirm work cover's decision, set aside the decision, substitute a new decision, or set aside the decision and remit the matter back to work cover for additional investigations, with work cover then being able to make a new decision based on additional evidence. So provisional liability isn't the same thing, but if there's an issue about whether the claim should be accepted, it should be raised with work cover. Those matters, if you have a problem with the injury, if you think that the claimant is dodgy or can't be trusted, or that the injury didn't occur at work, by all means, you should raise that with the claims officer from work cover, because it gives them additional avenues of investigation. It allows them to ask questions that they might not have asked otherwise. So don't simply accept every claim at face value. There are plenty of times when, I wish employers had asked a question, right? As opposed to saying, yes, the injury happened at work. Okay, well, that's one part of the question. It's not the whole question. Did the injury happen because of work? Again, there are claims, one that I just got recently, which is very similar to my previous example about simply walking down a set of stairs. That is a relevant example that I actually have a current claim for. So ask the question. Don't simply accept that the injury occurred because of work, and don't simply accept that that the claimant is without any kind of potential for misdeeds or fraudulent activity. We see a lot of those as well. We make regular referrals for fraud based on evidence that we obtain, and also evidence that was on the statutory claim at times that was overlooked because certain questions weren't asked. Because when you get two reports and they're months apart, when you're dealing with the claim on a month-by-month basis, you don't see the connection, or you might not see the connection between those two things that are identified in the reports. Obviously, when we get the claim, we're reading the reports, chronologically, within a couple of hours. So all of a sudden that, event or that issue becomes wildly apparent, but it wasn't at the time. So ask questions. Don't be afraid to put a position down. But at the same time, if the claimant is genuine, if the injury is genuine, by all means, right? It makes sense to say, yes, that occurred at work and because of work, and this is a genuine injury claim.
Sorry, and as Phil said, always talk to your work cover case manager, or they're called claims representatives, when they're making the statutory decision. It's important we get information from employers and workers. It's part of what we call procedural fairness. So we hear both sides and make a decision with as much information as we possibly can. So that side of it's important too. Was that all for the questions you had on notice?
That's all the ones that I got.
I can start throwing them at you from
Yes, of course.
screen. Someone has expressed incredulity at your case examples. I think you explained that quite well at the end. Someone has asked whether a diagnosis is required from a psychiatrist as opposed to a GP. I can speak to, I suppose, the stat side with work cover. We routinely accept GP diagnoses for most psychological injuries. With PTSD, just as a matter of practice, we would often, I'm not sure if it's as a rule, but we would often try and get an opinion from a psychiatrist, whether that's an independent or treating, or I suppose accepts it provisionally and investigate it a bit more later when it's clear there is an injury, a diagnosed injury that should be accepted under the definition in the Act. But for, I suppose that speaks to the first part of the claim, but once you're at the damages phase, I suppose, can you speak to how often we get independent reports at that phase of things?
So in pretty much every instance in a common law claim, there will be an independent psychiatrist report, and there will be a diagnosis in that report. Most times when there's a psychological injury claim, well, in essence, all times, especially in the statutory phase, they have to go through the medical assessment tribunal and have a diagnosis from a panel of psychiatrists. So we will have a definitive diagnosis at some point when the claim arrives to us, especially if it's an accepted psychiatric injury, more cover. Obviously, there are plenty of claims where we get unassessed secondary psychological injuries, depending on the evidence and depending on the level of impairment from that, or claimed impairment, I guess, from that secondary psychological injury will depend on whether we get a report before attempting resolution or not. Again, each case is on its own facts, to be perfectly honest. So yes, we will have a diagnosis if there is an accepted psychological injury.
All right, excellent. We've got a question asking who assesses whether management action is reasonable. So that happens at the stat phase, as you said. So it would be a work cover claims representative making the decision about the claim as to whether it was reasonable management action or management action undertaken in a reasonable way is the second part of the test. Someone has asked if, I'm sorry, and the second part of that was on what basis. I suppose we're guided by lots of decisions from the regulator and the QIRC that we've been able to see over the years. So we're guided by case law essentially on those. Obviously, the wording of the legislation first, and then case law if it's ever grey. Not sure to what extent you can talk about this, but someone has asked for some sort of practical guidance on workplace modifications or what they can do in the workplace to help avoid risks of psychological injuries. Obviously, nothing we say is advice, but from your experience, can speak about anything you've seen?
So actually having policies about bullying and harassment, you'd be surprised how many claims that I get where there are employers, and most of those are smaller employers, smaller organizations that don't have the resources to make those policies. So having policies of any sort is really important. And there are organizations that can help draft those policies for you. They, a lot of them have template policies they can provide, at very little cost, but it's more so an employment law question as opposed to a work cover question, to be perfectly honest. But there are steps that you can take. There are employment law firms and organizations, that help smaller organizations to draft, relevant health and safety policies. So yeah, I mean, I would definitely search, Google, that kind of issue, employment law, workplace health and safety policy. I mean, that would be a reasonable Google search, I would have thought.
Yeah, and I think those two, the reports, the other document that I mentioned at the start, I think Yolanda's put those up, the links up in chat already, and they talk about those sorts of things as well in a helpful way. All right. Someone has asked about assault in the workplace and whether assault could ever be considered RMA.
I've never seen assault be considered RMA before.
Yeah.
That would be unreasonable management action, and it would unlikely be called management action in any sense.
Wouldn't like management action in the first place.
Yeah, that would be the bigger problem, is that it wouldn't be management action, even though it might be undertaken by a manager. It might not be management action. So again, I kind of refer back to my previous slides. It has to be about the employment, and the way that they are employed. That's management action. So again, there are numerous cases that you can refer to and read. It's worthwhile reading those cases from the QIRC about reasonable management action. And again, it is a simple Google search. If you know how to Boolean search, I would use reasonable management action in quotes, and then Queensland as a second word, and you'll get a fair lot of results from that.
Yeah, and the court websites are helpful too if you wanted to
most certainly
look at court cases. That you can put in reasonable management action in inverted commas and get a few Supreme Court cases that way. So we've got quite a few questions about pre-existing injuries, and I think you've talked about that a bit already. One I think that might be slightly different you can speak to is if someone's got a pre-existing that they don't disclose, and then that's aggravated in the course of their employment, how does that affect the employer's liability? Which is an interesting question. I suppose it's also relevant to physical injuries that people don't disclose that might be aggravated in the course of their work.
It most certainly is. So we get a lot of that, actually. And there are sections in the WorkCover Act which deal with non-disclosure of pre-existing injuries. However, to meet the threshold to deny a worker common law rights, there has to be a number of very specific steps undertaken by the employer at the initial employment stage. You have to provide a full detail of all the tasks that the employee is going to undertake. You then have to ask them specifically, are any of these duties going to cause you any injury you may have to be aggravated? They then have to confirm that that's the case. A lot of the times, one or more of those steps are missed in employing someone. Even if you ask if they have pre-existing injuries and they say no, if you didn't give a full detail of their entire tasks, then that wouldn't be an issue that the regulator would deal with. It would just be unlucky, to be honest. And it's sad to say, but we deal with that all the time. Employers are really aggravated because they say, well, you had this pre-existing injury, didn't tell anybody about. It's been aggravated. Well, yes, that's true. But at the end of the day, the issue is the aggravation caused because of work? Or they work, or all the other relevant questions that have to be asked. And if so, then does the injury sound in common law damages? I mean, for me, that's the question I get asked a lot. So unfortunately, pre-existing injuries are pre-existing. They have no requirement to tell you about it unless you specifically ask, and do so in a way which is required under the legislation. So I would go back to the Act, read that, and get specific employment law advice about that aspect if that's something that you want to undertake, because it can be quite an issue at times if you do it incorrectly.
Someone here has asked if claims representatives at WorkCover should know about the at work versus caused by work issue. Very much so, yes. I think that the term I hear them use is was work merely the setting for the injury that happened. So, if you're having a conversation with the claims rep about a particular claim or someone at WorkCover about a particular claim, you can sort of use that language or really anything to make sure that they're alive to that issue. But they should be very much across whether an injury was caused by work, because the legislation talks about work being a significant contributing factor. All right, I'm sorry, a flurry of questions has just popped up at the end, and now I'm a little lost. I think one of the ones we had on notice was what's the average cost of a psychological injury claim in damages, and that's not something you can really guess at because every claim is different. But maybe if you could talk about just very briefly, because we're nearly out of time, just sort of the heads of damage and just a general overview of maybe what you see as
Sure.
big factors.
Yep. So the first head of damage is general damages. General damages, everyone likes to refer to as pain and suffering, but it's not technically. It is an account in the workers' compensation rehabilitation regulations. There is a Schedule 9, and in that Schedule 9 details pretty much every injury that could ever occur and a range of numbers for that injury. You get low back injuries, moderate low back injuries, serious low back injuries, extreme low back injuries. And each one of those has a range of numbers. And also that schedule talks about, how you're supposed to identify how in the range that injury falls. Then that number, whatever numbers come up with or agreed upon, converts into a dollar amount. So every injury basically has a value. That's general damages. The next is past economic loss. Past economic loss is exactly what it sounds like. It is the loss that the claimant has incurred from the date of injury to the date of settlement. And it's usually something that's quite easily calculable. Sometimes there are some instances, especially with issues about pre-existing injuries, that they could have been not at work anyway because of that pre-existing injury. That then could limit that past economic loss. It could also limit future economic loss. We also determine those kind of things or estimate a range basically based on expert medical evidence. So the doctors then say, well, this person might have a problem with work in the future. They might be limited to working a certain number of hours. That then details, when you look at what they're earning, multiplying that out over time and applying discount factors. There are special damages. Those special damages are usually the cost of the stat claim, in essence, from what work covers paid for medical expenses, et cetera. And then similarly, future special damages. Same kind of thing. What kind of treatment is going to be required into the future? And then obviously there's other smaller things like past super, future super that they would have lost or did lose on account of the injury that occurred. So there are some things that work cover doesn't pay for either, which are entirely relevant to other types of claims, such as personal injuries preceding that claims that are only payable by those other third parties. Again, that's going way into too much detail, but some of those are care and assistance that's gratuitous. Some paid care can be paid in very specific circumstances. Again, it gets quite niche really at that point.
And future economic loss tends to be the big item.
It does tend to be. Obviously, the claimant's age plays a part of that. How affected the injury has made them. What level of disability they're suffering from, and what the experts come to in that regard, because we ask very specific questions in that respect, and so do the claimant's lawyers. They want to maximize that, we want to minimize that. So if we can, we do.
And I guess that's why one of the reasons a return to work outcome at the end of the statutory phase is so important. So, you know, what Phil touched on earlier, supporting and staying in contact with your worker and seeing if you can, if possible, get them back in the workplace. It's the best thing for the worker as well. All right, I think we've gone over time now. Thank you very much, Phillip, for presenting a terrific session for our audience. For everyone out there listening, thank you for listening in. We hope you found this informative and helpful. It's been recorded, and we will send out a link to the recording next week, and it'll be on our YouTube channel. And you can find all our previous common law webinars there as well. There's a playlist for those. That's all from us today at WorkCover, and I think this will be the last one for 2022. So thank you everyone who's joined us. We appreciate you taking the time and for the interesting questions. So we'll be back again early 2023 with a new series. So keep an eye out in your email, on LinkedIn, or on the events page at the WorkSafe website. Thank you once again, everyone, and stay safe during the holiday season. Thank you.